I'm going to take a few minutes now. I'd really like to look at the DUIs because so many people are affected by DUIs. We have everywhere from, my DUI clients are an amazing spectrum, from students to career military to owners of businesses to nurses, teachers, police officers. It's about the full gamut of, there's no income level, there's no type of job level, it is hitting everybody. So, I mean, I would be curious to know what percentage of Virginians have gotten a DUI charge. I mean, it's amazing how many and how frequently people are affected by this. But what I like to do is point out in the DUI law, if someone would come into my office charged with like a shoplifting, that person would walk into court presumed innocent until proven guilty. When I walk into court with a DUI defendant, my guy is, for all practical purposes, presumed guilty unless I can overcome the presumption. The reason that works is anytime there is a breath certificate or a blood certificate, that certificate is presumed to be accurate, and it's presumed to accurately reflect the blood alcohol level at the time of driving. So when I have to defend a DUI client, I have to talk to them about, look, they've got a presumption on this number. The avenues we have for attack are, there wasn't a good reason for the stop, there wasn't a good reason for the arrest, or some combination of factors that includes challenging the breath certificate means that it's not beyond a reasonable doubt that you were guilty of the DUI. When we are looking at a DUI case, we use a questionnaire, we go to the police. We ask for police records, we go to the Commonwealth Attorney's offices, we look at videos. There's 4 primary areas that we're looking for. We're looking for a medical, a scientific, a factual, or a legal argument. And I'm just going to give you an example of each of those, and then we'll just any questions you have about any area of traffic. A medical defense, my best medical defense, I think, was I had an expert witness in the federal court in Newport News. I had a military, Army sergeant. The sergeant was on a low-carb diet. And normally, it would be really hard to prove this. But the military gave him a blood test the morning after he was released from custody to test for drugs and alcohol. And we were able to show the presence that his body was being able to produce isopropyl alcohol internally because he had hit the goal of the low-carb diet and his body was processing out the fat. And we were able to show in his blood work that that was happening in his system. So the breath machine is sensitive to alcohol, but it's not as good at distinguishing between one type of alcohol and another type of alcohol. So we argued that this man was internally producing isopropyl alcohol in his system and that could have interfered with the level of alcohol in his system as measured by the breath certificate. And they brought someone who defended the Department of Forensic Science and that the machine can do all these things, and we brought an expert who was a medical doctor and an expert on the machine who explained why his medical condition would affect the result. Now, a good example of a factual dispute comes out of the same case. We had a situation where the officer testified that he administered a one-leg stand test which my client failed, referring to his notes. I asked him, when did you prepare those notes? And we had a miracle. No, we didn't have a miracle. We had a wonderful thing. We had an honest officer, and he explained that the way he prepared his notes was he took someone else's old computer list and edited it. That wasn't pronounced well, but he changed the old format into my client's. So what did that give the possibility for? That gave the possibility that the former guy's stuff was still in mine. Well, once I produced 2 witnesses, a guy following my guy who said no bad driving, and when I stopped and watched the field test, no one-leg stand was done, and I then produced the guy's senior representative who said, well, when I picked him up a couple hours after the stop, he wasn't wobbling, he didn't seem drunk, there wasn't slurred speech, and I had him standing at attention for an hour while I yelled at him. Well, it was really hard for the officer to make his case once we'd challenged a factual issue of there was now doubt about whether or not he did a one-leg stand, plus we had a challenge to the breath certificate. So that's just an example of, you know, it sounds horrible when you look at the facts of the case, and at one point in that case I was recommending that he take an offer that would have avoided jail time. But he was smarter than me, and he wanted the trial. And the factual issue and the medical issue combined helped him walk away from a DUI.